Yes, hello everyone. My name is CS Rachit and I'm part of Taxmann Research and Advisory team. I welcome you all for today's webinar titled CSR and Insight into Recent Developments. I'll be hosting this presentation today and it's a great pleasure for me to introduce our speaker today, Ms. Pammy Jaiswal, who is going to talk to us about the recent developments in CSR. Ms. Pammy Jaiswal is a commerce graduate and an associate member of ICSI. She is currently holding the position of partner in Vinod Kothari and Company. Her expertise lies in the field of corporate law, SEBI regulations, and FEMA. She has deliberated on various topics at several forums, including ICSI and ICAI. Before we move towards the webinar, I request all participants to feel free to ask their queries on the subject. Your mic will be on mute, so you may just write down your queries in the chat box. It will be answered by our speakers during or at the end of QA session. Now, I would request Ms. Jaiswal to take this from here and share her knowledge and experience on this subject with us. Over to you, ma'am.
Thank you so much, Rachit. A very good afternoon to all the attendees on today's webinar. So, before I start, I would like to mention something that CSR has been such a buzzing topic. And more so from the date the Companies Amendment Act 2020 was notified, and the whole concept of CSR underwent, a sea change. So, okay, am I audible to everyone? Is it the screen is visible to all, the presentation is visible to all, and the voice is audible? Okay, then I think we can move ahead. So, as I was saying, that CSR, once the Companies Act 2013, when Companies Act 2013 came in, it was a very new concept for the corporates, where they were required to spend something towards a corporate social responsibility. So when the Companies Act 2013 came in, CSR was a voluntarily exercise. I mean, in terms of the spending, because the main spirit of the provision is not only in constituting the committees or formulating policies or doing stuffs which eventually does not lead to spending and making a change in the society. So when Companies Act 2013 came in, this concept of CSR also traveled in our statute. But it was a comply or explain provision and not a mandatory provision in terms of spending. Why do I say that? I say that because there was a provision which uh, enabled the board of directors to explain the reasons for not spending the minimum budget allocated towards CSR. But from the 22nd of January 2021, the whole concept of CSR in India underwent a sea change. That is because from the concept of comply or explain, it became comply or pay penalty. Unlike in India, the situation is not the same when we see the global scenario, because while the corporate social responsibility as a concept, it is prevalent all throughout the globe and in several countries, but it is more in the form of laying down standards and setting, a good corporate practice in terms of showing the social responsibility. In India, after this change that came on 22nd of January 2021, CSR is no more a comply or explain provision. It has become a comply or pay penalty. So if we look at the series of amendments under the CSR provisions, it started way back in 2018 when the Companies Amendment Act 2017 were notified. followed by the changes brought in or suggested by the Companies Amendment Act 2019. And then came the Companies Amendment Act 2020, which got notified on 22nd of January. So what was so different between, Companies Amendment Act 2019 and Companies Amendment Act 2020? Companies Amendment Act 2019 was, you can say, it scared the corporates to such an extent that it intended to impose a criminal liability on the corporates in case they are not able to fulfill their CSR obligation. So that was something which was suggested by the Companies Amendment Act 2019. But subsequently, of course, after various representations from the stakeholders, the ministry thought about it and made the criminal liability to a civil liability, because what was suggested in 2019 was imposition of a fine in case you are not able to spend, which was subsequently changed to imposition of a penalty. So that's why I say it's no more a comply or explain, it is comply or pay penalty. So, here, before we delve into the several concepts of what is new under CSR, what we need to keep in mind, what are the compliances, what are the small nuances which we can skip while we are talking about CSR. Before going into that, one thing that is very important is to understand that if you do not comply with the minimum spending requirements which come from subsection 5 and subsection 6 of section 135, you have to pay penalty. What is the extent of the penalty? The penalty amount is twice the amount required to be transferred to the unspent CSR account, or the amount which needs to be parked or sent to any fund under Schedule 7, or 1 crore, whichever is lower. So the penalty amount on the company is linked with the quantum of unspent amount which is lying with the company. And this is not the end. The penalty is not only on the company but also on the officers in default. So what is the penalty on the officers in default? It is 1/10 of the amount required to be transferred to the fund specified under Schedule 7 or unspent CSR account, or 2 lakhs, whichever is lower. So who is an officer in default in that case? So officer in default can be, can be anyone. So officer in default, if I say officers in default, you can take the meaning from the definition given in the Act. So basically means those officers who are specifically given the responsibility to look after a particular compliance. So in this case, officers in default can be the company secretary, it can be the CFOs, it may also be any specific director which has been given this responsibility to see that the amount has been spent or it has been treated in the manner required under the law. Of course, when we say that officers in default can be penalized, we cannot say that the board is absolved from the responsibility. So that is what we'll come to know as we discuss further, that the responsibility now on the board and on the CSR committee as well as the chief financial officer is twofold now. So it's basically the responsibility has increased after this change. So to start with, when we talk about the applicability of the CSR provisions, that remains the same, specifically that there are 3 thresholds. And if a company hits any of the 3 thresholds, which is linked with the turnover, net worth, or the profits. So if the company has a turnover of 1,000 crores or more, or a net worth of 500 crores or more, or a profit of 5 crores or more in the immediately preceding financial year, that company is now covered under section 135. So when I talk about profits, we need to be very specific that we're talking about profits before tax. We're talking about PBT and not PAT. So this particular applicability, we need to keep in mind that this is not based on the immediately three preceding financial years, but if a company hits any of these three thresholds, and the most liable threshold which is mostly hit in case of companies is the net profit criteria, the profit criteria basically, so which is 5 crores or more. So if any of the thresholds are exceeded in the immediately preceding financial year, you are covered under section 135, and this year you need to do all the compliances which we'll discuss in the later slides in the with respect to CSR. Okay, when we're talking about applicability, it is important to understand that there is no exception for any kind of a company from doing CSR, because if you're talking about a public company, if you're talking about a private company, even if you're talking about a Section 8 company, they are all very well covered under the provisions of Section 135 in case they hit the thresholds. There is one case that I would like to mention here, which is also there on your screens. Is what about those companies which are under liquidation? Are they also supposed to, take care of their CSR obligations? So, a company which is under liquidation is, of course, not expected to have profits, and it has, it's going to be liquidated. So, there is no requirement of CSR expenditure in such companies, given the situation or given the stage at which the company is. Okay. Also, one more thing which was brought in as part of the applicability of Section 135 is what about those companies which have not yet completed 3 years for the purpose of testing the applicability? So you will ask me, why are we seeing 3 years? Because when we are seeing the applicability, we are seeing the preceding financial year. So from where is this question coming that we need to see, or we need to think twice that if a company is not in existence for the past 3 years, they are whether they are covered or not. So let me tell you, while the applicability is based on the immediately preceding financial year, but the spending requirement or your CSR budget is linked with your past 3 years profits. So basically, your past 3 years average profits is something which you need to consider while taking out your minimum CSR budget. And that is why this question or this proviso was inserted under Section 135 by 1, that if a company has not completed 3 financial years, then we will be taking the average of the preceding years for which the company has been into existence in case Section 135 is applicable. There is also a point that we've discussed on the slide is whether a company with negative net worth will be required to undertake CSR expenditure. So a company, let's discuss in this manner that what is CSR? A company which is in existence, it is operating in the society, it is taking its resources from the society. By virtue of this provision, which is Section 135, the law has mandated that you should return something to the society, right? Because if you are earning profits, if you are reaping the benefits of the resources that you're using for your business, you should also be responsible enough to return it back to the society. But if you look at a company which is having a negative net worth, which is not, whether in the preceding, let's say in the preceding year, it has crossed the profit threshold, but when we move and when we take out the minimum CSR budget, which is 2% of the average 3 years profits, it's very unlikely that the company will have any CSR spending required, because it will have brought forward losses, because of which there will be eventually there will not be any CSR spending obligation. Okay, I have received a question from Mr. Aditya Jain. So, Mr. Jain, I will be taking your questions. I'll be completing the applicability slide and then I'll be taking up your question. So, I'm talking about the CSR applicability. So, here I also need to mention that when we look at the applicability, we do not see if the company is a holding of another company or a subsidiary of another company or an associate of another company. We have to see the applicability for CSR provisions on a standalone basis. So, if let's say if my company is a holding company, I will be checking the applicability for the holding company separately. And if there is a subsidiary company, the subsidiary company will be checking the applicability at its level. So just because, for example, the holding company is not covered under 1835, that does not mean that we will take it implied that the subsidiary will also not be required. Okay, so there is a question whether foreign branch and for a representative office of foreign bank are also covered in CSR. So, for example, if that branch has been opened in India in the form of a company, because a foreign company is also covered for the purpose of CSR provisions. So there is no exception for a foreign company as well. So we'll have to see what is the nature for, because 135 is applicable on a company. So if the company, if that branch has been set up in the form of a company here in India and it crosses the thresholds, it meets any of the thresholds, then 135 becomes applicable. There's another question from Mr. Ajay Gupta. What about the applicability on companies under IBC process? Now, IBC process itself is a long process, and it doesn't mean that if the company has gone into IBC into resolution, it need not comply with the provisions. So, in case it fulfills the conditions, it exceeds the thresholds, the requirement of CSR should still be applicable in my view. So moving ahead with the CSR applicability, let's move to CSR expenditure. Now, I would like to state here that when I look at the CSR provisions, it's very important that CSR provisions are looked at not only in terms of setting up of a committee or framing a policy and doing other secretarial stuff. The main intent is to devise a strategic and a holistic plan by which you know that you want to achieve this change in the society, and for achieving that change you have set a roadmap, and of course for implementing that you need to spend money. So that's the main spirit, or I will say the main atma of the CSR provision, that you need to spend. Because if you're not spending and just doing other compliances, it makes no sense under the, looking at the intent of the CSR provisions. Okay, so as I was saying, the CSR spending limits, you can say there is a minimum CSR spending limit and there is a maximum CSR spending limit. When we are talking about the minimum limits, it is given under the in the provision itself that it is 2% of the average net profits of the immediately 3 preceding financial years. But when we talk about the maximum CSR expenditure, there is no limit. It is at the discretion of the board. Of course, the board also acts as per the recommendation of the CSR committee. So let's take an example that the company in question, for example, A Limited, has fixed a minimum CSR budget of 5% of the average net profits of its immediately 3 preceding financial year as the CSR budget. So, how much will it require to spend? When can I say that it has completed its CSR obligation? Because the company itself has set a stricter framework for itself, and let's say this fact has been provided in its policy itself, that for the company the minimum CSR budget will be 5%. In that case, the stricter limit will apply and not the one which is given under the provisions. It's important to understand that when we're talking about CSR expenditure, we are talking about actual spending. We are not talking about doing CSR in kind. When I say that, it means that, let's say, I am a company which is into, I mean, which is in the FMCG sector, and has several of such goods which can be used in, let's say, day to day ration, or maybe the sanitation, etc. And I have such goods in my godown, I have such stocks with me. I can simply take out the stock and go and distribute it to the public and say it's a CSR. In my view, it's not a CSR. Why it's not a CSR? Because what I have done is I have simply taken out the stock from my business. I've taken that stock and I've distributed. I've actually not spent anything. Now you will tell me that for buying that stock I must have spent earlier, but we have to understand here, this particular view has also been reiterated by the MCA, and we have also had this view that when we are talking about CSR spending, you have to actually spend the amount. So let's say today, if your budget has come to 10 lakh rupees, you cannot simply take out the stock worth 10 lakh from your go down and distribute it to say it's a CSR for you. It's not CSR. For you need to actually spend that 10 lakh rupees to actually be in compliance with the provisions. So spending is in kind is not CSR, that we need to be very clear on. Now you will also ask me a question that what about, I mean, what if a situation comes in that I have spent 10 lakh rupees for procuring certain goods, and I have distributed those goods. Will that not be a CSR? Of course that will be CSR. There's no doubt. And I mean, as long as you are spending the amount and the activity in which you are contributing is falling under schedule 7, and you are following the other compliances, as like for example you're monitoring, you are keeping a record, you're reporting the same, it is surely one which should be called a CSR activity. But simply taking out stock from your go down and distributing them is not a CSR enough. The second point that I would like to discuss here is contributions to corpus of a trust. There has been several questions, in the past that we've received after the amendment, that whether contribution to a corpus is a CSR or not. So before understanding that, let's understand what's a corpus. What is a corpus of a trust? So simply, if I say what is capital for a company is what a corpus to the trust is. So something which is permanent, which is going to stay with the trust, till it's there. So if the contribution from the company is going to a general corpus, which has no specific end use, which has no, monitoring system, which has no, it can be spent in anything, in any philanthropic activity, in any charitable activity. In that case, such contribution to such a corpus, such general corpus, should not be eligible to be a CSR expenditure. However, if there are safeguards, so what are the safeguards? One, it's not a general corpus, but a corpus set up for being spent in, activities, in areas which are covered under Schedule 7. There is a proper mechanism of reporting and monitoring where the money has gone. And of course, the company, while it is making the contribution, it is taking the cognizance, it's completely aware that this amount which it is contributing to this specific corpus is going to be used for the activities for which it has given the money. So once these safeguards are in place, we do not find any issue that such contribution should not be taken as a CSR. Because if I am spending the money for an activity which is covered under Schedule 7, also not only contributing but also monitoring the such expense, taking the updates, there is no reason why one should not consider such contribution as a CSR expenditure. I am receiving several questions on CSR expenditure, so I will try to take them up now, and if not now, of course, at the end of the session, because we have several things to cover here. I mean, under this CSR webinar, so we'll try to first finish and cover the main amendments, and then we'll take up the questions. Another very important change that was brought in by this 22nd January notification is the way or the mode by which you can spend the money. So earlier also, for spending the money, you can directly spend, you can directly do CSR activities, or you can do a joint collaboration with another company, or you can do it with the help of a trust society, section 8 company, either which is set up by your company, or a public trust or a society having a specific track record in the activities for which you're giving the contribution. After the amendment, the concept which has come in is either doing CSR directly, that is of course self-implementation, or a joint implementation, but that too directly with another company, or doing it by way of an implementing agency. So what is an implementing agency here? Implementing agency is an agency which, of course, as the name suggests, you will not find this term anywhere under the CSR section 135. I think somewhere under the rules they have mentioned about the agency, and of course under the annexure 2, which is the CSR report, they have mentioned this word implementing agency. So it's supposed to act as an agent of the contributor, which is the company, for identifying the CSR opportunities, coordinating with the end beneficiaries, and also helping out in monitoring the CSR spending. So which are the 4 types of agencies? First one is of course the captive agencies, like the section 8 company, public trust society, which are set up by the company itself, right? So if I'm A Limited, let's take the same company. A Limited has set up a section 8 company, and it is doing CSR through its section 8 company. So I will not say it's doing CSR activities directly. It's not a case. It's not a case of direct CSR. Direct CSR is different from doing it by way of an implementing agency. When we are doing CSR directly, let me give you an example. I have received a request letter from a hospital that they need to set up 100 beds. What I have done is, I had one of my priority projects in the field of health and sanitation. So in my CSR committee had already recommended some amount of my CSR budget, and it has allocated the same towards this priority project. So the CSR team or the secretarial team or whoever who takes who's in charge of the CSR compliances has sanctioned the requisite amount to this hospital for setting up 100 beds. So this activity or this contribution that has taken place is a case of direct CSR. It's not a case of doing it by way of an implementing agency, because I am spending the amount directly to the beneficiary. There is no agency involved. I cannot say that the hospital is the agency. No. In that case, this chain will never end. I'll have to keep identifying who is the actual or the end beneficiary. And what will be a case of an CSR by way of an IA or an implementing agency? Let's take another example. The A Limited had engaged XYZ Foundation to identify the CSR activities for A Limited. X Limited has received a request letter from a hospital for setting up of 100 beds, and XYZ Foundation has forwarded that letter to the company, right? So what the company does, company has contributed or company has given certain amount of funds to XYZ Foundation, which in turn examines the letter, examines the authenticity, examines how bona fide the request is, and based on its discretion and based on its expertise disburses the amount. So here A Limited is not doing CSR activity directly. It is actually doing or carrying out the CSR through an IA. So, in case you're doing it through an IA, you are relieved of at least, the fact that you don't need to identify or keep identifying several, CSR activities from time to time or projects. That work can be given to the implementing agency, and they, because they are expertise in this field, they have expertise in this field, they can give you, suggestions, and based on their discretion, based on their examination of how authentic the request is or how authentic the project is, they can make the disbursements. Of course, when I say that the disbursements are done through the IA, it does not mean that the discretion is, without any fetters, because the main fetters are already set by the CSR committee when it recommends the budget as well as the allocation of the budget. So where, what, let's say, what's the amount and where the amount is supposed to be spent. All that is already recommended by the CSR committee to the board, and board approves it, based on which the disbursements go to the IA. So we were talking about the types of IAs. One was the captive. The other one is the government agency. So basically, Section 8 company, trust or society set up by the government that also can act as an IA. Then comes the statutory bodies. Any entity which has been set up by an act of parliament or state legislature, they may also act as CSR implementing agencies. Fourth is a Section 8 company, a public trust, or a society set up by other than the company. So any public trust, public society, which is not set up by the company, which is not captive, and which has a track record of 3 years in the field. So track record is a must for public agencies, not the captive agencies, but public agencies, which includes a Section 8 company or a public trust or a society, to act as an IA. So what these IA will need as a prerequisite, or before they start acting as an IA, what will they require? First thing that an implementing agency requires is an MCA registration that is to be done by way of filing CSR1. Second is that if it's a case of a Section 8 company or a trust or a society, right, in that case, they will also need a registration under the Income Tax Act, which is Section 12A and Section 80G. And in case of trust specifically, there are several states which require mandatory registration of trusts. So that registration is also required, because the language used under the provisions is a registered trust. So let us quickly move to the CSR activities and exclusions, which are important for today's discussion. Again, I would like to repeat here that the questions which have been posted on the chat box with respect to CSR spending, I'll be taking them up at the end of the session. So you need not worry. The CSR activities, so prior to the amendment, there was no specific list which was kind of an exclusion that these 3-4 items are not your CSR activity. In case you do them, it's not a case of CSR. But now law has clearly prescribed what is a CSR activity and what are not included, which activities do not qualify for being a CSR activity. So CSR activities, we all know that if you spend for any activity under Schedule 7, it's a case of, you end up doing CSR. But we need to keep in mind that what is not a CSR activity. Any activity which is undertaken as a part of your normal business is not a CSR. So what is, this ordinary business or normal business? There was a question, I think, which was posted in the chat box with respect to a pharma company. So I think there is a time-bound, exemption in case of a pharma company, which you can see on your screens also, that because of this pandemic, this exclusion specifically excluded a pharma company from carrying out or doing a R&D activities for new vaccine, drugs, or medical devices, which is to be done in collaboration with certain institutions under Schedule 7. And this uh, special treatment to pharmaceutical companies is only applicable till FY 22-23. And the fact that they are taking up their normal business as the CSR activities should be disclosed in the annual report. So it's very important to understand here that any company which is doing its business, if it starts distributing goods free of cost and start taking them as CSR, companies will never come outside their purview, or they will never come, go outside the boundaries of what they're actually doing. And CSR in fact gives you that great opportunity to explore what all new activities you can do so as to make a change in the society. So any activity which is your normal course of activity, for example, as I mentioned, if you're in a FMCG sector, or let's say you're a medicine pharmaceutical company, or let's say you are a company which is into um, making for example, your company makes products which are used for education, for let's say stationery items. So you cannot start distributing those goods and say that you are doing CSR. We need to understand here that of course, in the normal course of business, I will never distribute goods free of cost. So there is a difference between distributing goods free of cost and selling your goods. What I do normally is I sell my goods. I do not distribute them for free. But if you take this argument, and if you want to, stick to this argument that because of this, I cannot say that distributing the, my stock in my go down is not a CSR, then you will never, a corporate will never go outside the actual boundaries of what, an actual CSR would actually look like. So while there is a very thin borderline, we are very clear on this view that you cannot and you should not distribute your goods for free and call them CSR. Next is activities outside India except training of sports personnel, because of course India needs your CSR activities, not any other country. So this provision is there to benefit the society in India and not outside. Third is contribution, direct or indirect, to a political party. So, of course, contribution to a political party can never be taken as a CSR. Fourth exclusion is activities benefiting employees. So here we need to understand. I'll try to explain this in very briefly here. That if the CSR activity has been so devised that it is exclusively for the benefit of your company's employees, or your group company's employees, it is not a case of CSR. However, if the activity is open for all, where your employees can also be part of, they can be also one of the beneficiaries, there is surely no problem. The company can surely go ahead, and this activity which is open for all, including the employees, should be qualified as a CSR activity if it's an activity under Schedule 7. The next exclusion is sponsorship for deriving marketing benefits for products and services. Here also, it's very important to understand that when a company does CSR, we are not saying that it needs to remain selfless. It needs to be, completely altruistic on what what it is doing. When you're doing CSR, a company is expected to put forward its name that yes, I am A Limited is doing the CSR activity. But in terms of priority, your intent should first be to make the change in the society, and secondly, it should be, bringing up this goodwill or brand building of your brand building exercise We are not saying there should not be a brand building exercise. I mean, you should not mention your name when you're doing. You should be an anonymous contributor. No, you should surely be putting up your name when you're doing a CSR activity, but that should be a secondary or a collateral benefit that is arising while you're doing the CSR activity. It should not be the primary intention. And the last exclusion is any activity which you're doing as part of your statutory obligation. That again is not a CSR activity. There have been several changes in Schedule 7, which I think you all can see, and that can be referred to also. That's not an issue. And also, very recently, I mean, in the last year also, and this year also, MCA has been very kind enough to, keep bringing in clarifications and relaxations in view of the pandemic. So there have been several notifications from the MCA wherein it has said that, let's say, if you're putting money in PM cares, you are contributing for the benefit of CAPF or paramilitary forces or their dependents, veterans. That will also count as a CSR activity. So they have actually enlarged or expanded the scope of Schedule 7. And in any event, there was a circular in 2014, way back in 2014, where it was very clear from the intent of the lawmakers that we need to interpret the activities liberally, which are given in Schedule 7, and not in a restricted manner. Coming to the CSR compliances, I mean, I'll quickly take you through the compliances. So, as I was mentioning, that in case your company is, has crossed the threshold, CSR provisions become applicable. So, what you're required to do? The first thing that you're required to do is to set up a CSR committee. You have to draft a CSR policy, and of course, you have to take out the budget, allocate the same, and set the roadmap for actually spending towards the CSR activities. So CSR committee, if you look at the provisions, it should be constituted with minimum of 3 directors, and at least one should be ID. So what in case your company is a private company? So of course, if in case your company is a private company, it does not require an ID to be appointed, and it can also have only 2 directors. So there is no issue in case you're only constituting a CSR committee with 2 directors and without an ID in case of a private limited company. Okay, there was some questions on the constitution of committee as per the amendment also, which we can discuss here for some time. That do we need to constitute the committee every year? So the answer is that the applicability of CSR has to be seen on yearly basis, right? So let's say in 2021-22, CSR provisions are applicable on unlimited. So it has constituted the committee. In the next year, which is 22-23, it will check the applicability again. If CSR provisions are not applicable, it does not mean it will dismantle or dispose of the committee, because CSR committee is not, I mean, it's not giving you any, any difficulty if you have a CSR committee, because if CSR is applicable on you, you will be, the CSR committee will be required to take care of whatever are its roles and responsibilities. But in case CSR is not applicable on your company, you just simply don't call a meeting of the CSR committee. That's it. I mean, that's the only thing you need to do, that you do not call a CSR committee meeting. But for example, this non-application or non-applicability of the CSR provisions carry on for 3 years. So 22-23, 23-24, 24-25. CSR provisions are not applicable. Then the rules itself state that you can, do away with the CSR committee in that case. Because then if 1 year you have seen, it's not applicable. 2nd year you have seen, it's not applicable. 3rd year also, it's not applicable. So you can now, think that, of course, your company will take some time to, again, cross thresholds and be once again a company covered under CSR provisions. So you can dismantle or do away with the committee. There is one more change which the amendment brought in the context of a CSR committee was in case your CSR spending obligations is only up to 50 lakhs. In that case, you need not constitute a committee, and in such a situation, the board can take care of the compliances. So this situation is most likely to be there in case of first time applicability, because a company which has been always been into doing CSR activities, if 1 year its obligations fall below 50 lakhs, it is not such that you will not call a CSR committee meeting and board can only take care of the compliances. While that can be done, but when an SOP has been in place, that the committee is doing the taking the care of the recommendation part and the board is approving it, so that practice can be carried on. Okay, so we were talking about the role of the CSR committee. Yes, it has a very, very, important role, because starting from the CSR policy formulation, from identification of the activities, recommending it to the board, reviewing the status of the expenditure, monitoring the CSR activities, appointing any IA, or you can, the CSR annual report. So all of that needs to be done by the CSR committee. So CSR committee is surely having a very, very significant role to play. Another very important aspect that needs, a very short discussion is framing of CSR policy. To be very frank with all of you, what we have seen is, prior to this amendment, in fact, now also there are companies which have simply reciprocated and put in the provisions in the policy. They've just given the name of the company and the section 135 and the CSR rules, and it is said that the board has approved this policy. Do you think simply reproducing the provisions will actually do the job of a framework which was the intent of the lawmakers? The answer is no. The CSR policy, it should contain several significant aspects of your CSR framework, and the lawmakers have clearly identified this gap which was there, and they've specifically mentioned that your CSR policy should be having several things, and minimum of what you can see on your screens, that what is the philosophy of the company on CSR spending, what is the targeted approach, what is the process of implementing your CSR obligations, what are the modalities of execution, what will be the guiding principles for formulation of annual action plan. Now, this annual action plan, what is an annual action plan? This is again a new word. This was not there before. Annual action plan is a yearly plan which your board will have to approve, which will contain several aspects of your CSR obligation, like which are the areas where you're going to do the CSR, how you're going to carry out the CSR activities, will you have any implementing agencies, how will you monitor your CSR activities, and what will be the reporting framework. So all of this will have to be there in your annual action plan, and this plan needs to be approved every year. What is required to be there in your CSR policy is the guiding principles for formulation of the annual action plan. Next, your policy should also have a process for monitoring and reviewing of the projects or programs. It's very important, friends, that we need to understand. Simply giving a check is not CSR. Even when you are doing a direct CSR, when you are, when you have given the check to that hospital for 100 beds, as we were discussing in the beginning, there also you are supposed to take a receipt from that hospital that, see, we have used your money for this, for placing order with this particular entity for getting the beds. So simply giving the money and forgetting about it can never be a case of CSR. You need to actually monitor it. You need to review the projects. You need to review the activities to see wherever there are gaps that need your attention. Another very, very important aspect in your CSR policy is the treatment of the surplus arising out of your CSR projects. So, surplus arising out of CSR projects shall not form part of business profits. This statement has to be clearly mentioned in your CSR policy. What is a surplus? That's very important. What is a surplus arising out of CSR projects? So, let's take an example that I have chosen one of my priority projects of CSR to, for sustainable agriculture. So I have imparted training to several farmers. I have, I mean, given them the seeds, and they are doing the farming, and the company is taking care of the cost. So whatever produce comes in, that produce will, once sold, will give you money. So that is something which is arising. So that amount or that money is arising out of your activity, your CSR activity. That you can say it's a surplus. That again has to be plowed back for the CSR activities itself. Second example, in case you're running a school for a very minimal fees. So whatever fees is collected at the end of the year, that amount is again a surplus arising out of your CSR activities. The third example that I would like to give here is that's actually in the context of a very, very interesting topic that I'm just about to start in some time from now, is the concept of unspent CSR amount. So unspent CSR amount, once the company has an unspent CSR amount, it either has to park it in the unspent CSR account or transfer to any fund under Schedule 7. But there is a timeline given. So that timeline is what? For putting the money in the unspent CSR account, you have a timeline of 30 days from the end of the financial year. And in case the amount is to be transferred to any fund under Schedule 7, you have 6 months time from the end of the financial year. During this time, the company did a fixed deposit, or you can say it has put money in a interest earning bank account, and that money has earned interest. What do I say? Is this interest a surplus? That's a very interesting question, because if you look into the intent or the language of law, it says any surplus arising out of your CSR activities. So when the unspent account is lying with the company, it is not doing any activity. It's just lying with you. So you either had the option of putting it in a non-interest bearing account, right? But you chose to put it in an interest bearing account. So any interest that is coming in is not coming from a CSR activity per se. But if you look at the MCA's FAQs or their views on this, they said that the interest component is also a surplus. While we slightly differ from that because of the fact that the language is CSR activities, surplus arising out of CSR activities. My obligation is to do CSR activity. And if while doing the CSR activity, if any surplus comes in, and if that surplus is used by me for my business activity, that is wrong. But if the amount is lying idle, there is time value of money, and I have put it in an interest bearing account. So I am simply using that interest, not the unspent CSR amount, for any purposes that I would, even for the business purpose, that should not be taken as a surplus, and therefore can be used by the company. As I mentioned, a very, very interesting topic that was brought by this amendment was the concept of unspent amounts and ongoing projects. So let us discuss this very, very interesting topic. Is before the amendment, as I mentioned, let's say I've fixed a CSR budget of 10 lakh rupees. So at the end of the year, I was able to spend 7 lakhs, but 3 lakhs is still not spent, right? So simply what I was required to do is that my board, taking the same company, A Limited's board of directors will have to give a reason for not being able to spend the amount of 3 lakh rupees. That's it. After the amendment, there is a concept of ongoing projects. So, what is an ongoing project? Ongoing projects means a multi-year project, which is, for more than one financial year, which has a commencement and a completion date. So, if my company has committed that it is going to put money in an ongoing project, and that ongoing project will take some time to complete, in that case, if let's say in the first year when I approve that ongoing project, I can a mere commitment from the board of directors should suffice in our view that it is uh, it is sure that the company is going to put money in an ongoing project. Now, in the amount that was freezed or that was allocated to this ongoing project, for example, was, let's say, 10 lakh rupees. At the end of the year, company could spend only 1 lakh rupees in the first year when it has approved the ongoing project. So the remaining 9 lakh rupees is required to be spent on the same ongoing project within a period of 3 financial years. So, in case the company has chosen an ongoing project and any amount related to that ongoing project is not spent, such unspent amount has to be transferred to a unspent CSR account within 30 days of the of the 30 days from the end of the financial year. Whereas, if the amount has been allocated to a non-ongoing project, so for example, uh, the company has allocated its budget for, distribution of books to the underprivileged children for their primary education. So that is something the company does every year. It's not an ongoing project per se, because there is no other blueprint or a plan on this particular aspect. They simply, get a request letter from some foundation, which again receives it, which receives this request from, a very small rural school, which runs, which takes care of the education of the underprivileged children. So there, the company simply gives the money and takes the reporting, and every year this happens. So if this kind of a project is approved, I will not say it's an ongoing project. It's a not ongoing project, because there is no need for, this project having a commencement or a completion date, right? And it's not a multi-year project. When I say it's a project, of course, what I mean to say is the activities are, subsequent to one another. They are commingled, and they are all directed towards achievement of one particular target. For example, construction of a hospital or construction of a school building. So that one can say it's an ongoing project. So law has given a time of using the unspent amount for ongoing projects for a period of 3 years, excluding the year in which such ongoing project has been approved. So I have already mentioned about what we do with the unspent CSR funds in case it's related to an ongoing project, and what should be the treatment in case it is for a non-ongoing project. Another important definition that was brought by the amendment was the meaning of administrative overheads. So what is an administrative overhead? That is the question. Law has specifically given the definition to state that administrative overheads means the expenses incurred by the company for general management and administration of corporate social responsibility functions in the company. So that's not it. So that's a general definition, but it further states that it shall not include the expenses directly incurred for the designing, implementation, monitoring, and evaluation of a particular CSR project or program. So that means, in case your money, your CSR budget has been spent towards designing, towards implementation, towards monitoring, or towards evaluation, you cannot say it's an administrative overhead. So what is the relevance of an administrative overhead? So administrative overheads shall not exceed 5% of the total CSR expenditure. So whatever is the total budget, administrative overheads cannot be more than 5% of that. So very recently in the month of August, NCA had brought another set of long FAQs on the amended CSR provisions, and it had dealt with what can be administrative overheads, what cannot be an administrative overheads, and they mentioned that involvement of employees cannot be monetized to claim CSR expenditure, whereas if you are incurring training cost for your employees which are involved in CSR, that can be taken as a administrative overhead. The last leg of our discussion is on the monitoring and implementation. So what is new under this? We all knew that CSR from the very inception in 2014 when it came, it was not only a check giving activity. It always had this requirement of monitoring. What is new after this amendment? Let's discuss that. The new part is, first, the amount which is disbursed by the company, the board has to ensure that it has been used for the purposes for which it was given. And to that effect, the CFO or any other person responsible for the financial management will be giving a certificate that yes, the funds have been utilized, or of course, whatever is the status, to that effect, a certificate from the CFO will be taken. So when I'm talking about monitoring exercise or self-ensuring exercise that the money for CSR has gone into CSR, the responsibility of the CSR committee, the board, and the CFO. So taking a certificate from the CFO is just acting as an additional security, but that does not absolve the board or the CSR committee from its responsibilities to actually ensure that the money has gone into the specified projects. When I talk about the other part which is new with respect to monitoring is the amount which is given to an implementing agency. Let's say I had a CSR budget of 10 lakh rupees. I gave 6 lakh rupees to an IA for CSR spending. At the end of the year, the IA could spend only 4 lakh rupees. Can I say that I've spent 6 lakh rupees? The answer is no. Right? So the answer is no, because unless the amount has been spent for the CSR activities, you cannot take it as spent. So that is very important. There are several changes under the annual report on CSR because of the new terms being coined in after the amendment, like the implementing agencies, ongoing projects, not ongoing projects, etc. Also, very significant change was that after this amendment, if a company has acquired a capital asset pursuant with CSR activities, such capital asset can only be kept in the name of the implementing agency, like the Section 8 company or a trust or a society, and not in the name of the company. So there is a very elongated format under Annexure 2 of the CSR rules, which you can find. And another monitoring exercise, or you can say an evaluation exercise, is with respect to impact assessment. So what is an impact assessment? This is also something new. So we all knew that monitoring was always there, but there are certain more safeguards or additional security features, you can say, in case of monitoring of CSR expenditure that has been brought in. Besides the monitoring exercise, there is also a new requirement of impact assessment. So what is an impact assessment? Impact assessment is required in case the CSR target of the company in question in each of the 3 preceding financial year is rupees 10 crores or more, and the activity or the project has an outlay of 1 crore or more, and at least 1 year has elapsed from the completion of such activity. So these are the 3 conditions. If the company fulfills the condition, it requires impact assessment mandatorily. It will have to carry out the impact assessment. Who can carry out the impact assessment? Any independent agency. So who can be that auditor, or you can, that entity will be carrying out, is not mentioned in the rules. It's not mentioned in the provisions, but it can be, I mean, someone who is independent. So for example, there can be statutory auditors, there can be CSR professionals, certified professionals. It can be any other, I mean, let's say the secretarial auditors, the practicing C, or anyone who is having knowledge on the topic and who can actually carry out the assessment as per the intent of law. What is the format of this impact assessment report? Is there any format? Answer is no. There is no specific format. Of course, the assessment will be customized as per the project. It will have to be carried out in terms of the requirements of the projects, and there is no specific format. What is the timeline? So let's say there are 3-4 projects which the company is carrying on. So am I required to do impact assessment for all the projects? So impact assessment exercise is not a small exercise. We need to understand that, because it's like, to give you an example, if I had planted trees, it will take time to bear fruits. I cannot do the evaluation exercise or assessment exercise just after the completion of the activity. It will take some time to show the results, and when it takes time to show results, to measure the results, to understand the results, all of this is a, I mean, it's a time taking job, which is why we are of the view that you can take up the impact assessment on a rotation basis of your activities. Where is this impact assessment report required to be disclosed? So this has to be a part of your CSR disclosure, which is part of your annual report. And yes, so there is one question which I would like to discuss here. Is this impact assessment exercise, it's come now, right? It's effective from 22nd of January 2021. So can I say that for the projects which I have done in the past, so if I'm standing in 21-22, of course now I'm in 21-22, but when I was standing in 2021, were I also required to look at the preceding 3 years CSR targets and do impact assessment? In our view, yes. If you complete or you meet the conditions for impact assessment standing on the day of notification, there is no issue if you want to carry out the impact assessment. There is a limit which has been set under the law for impact assessment amount. So it has to be 5% or 50 lakhs, whichever is lower. And this is in addition to the administrative overheads spending. So it's not that the administrative overhead is a bigger set and the impact assessment cost is a subset of that. Both are different. So we need to understand that as well. So I think on the impact assessment part, that's it. One very important thing that I would like to add here before we take up the questions is, in case a company has done excess spending on from what it was required to do, in that case, it can take benefit, or it can set off the excess spending from the subsequent year's CSR obligation for a period of 3 years. This again is another change. So that's it. I think we can take up questions, Rachit. You will want to call out the questions, Rachit, or should I simply scroll the chat box and...
Yes, ma'am. You can scroll down the chat box and you can answer
Sure.
one at a time.
Okay, so there were questions on CSR spending. So there is one question from Mr. Jain, which is CSR in kind. Can pharma company giving free of cost medicine, excuse me, to poor patient is covered under CSR? So, Mr. Jain, here I would like to again mention that if a company is engaged in manufacturing of medicines, and if they start giving out their own products as a part of the CSR exercise, they will never find any other avenue. They will never want to go and explore any other avenue to see if they can do anything as a CSR activity. In our view, this exemption also, which was given, as a part of the exclusion list, was for an R&D exercise for specific to and very, very, specific to the R&D exercise for the pandemic period. So in our view, if you are a pharma company engaged in manufacturing of medicines, and if you want to distribute medicines free of cost, it should not be taken as CSR. There's another question from Mr. Ramesh Babu Kurala. Several houses fire burned. The company given cash of 25,000 to each houses. Sir, this will not be a CSR because I will actually, I'll just put forward a broader framework on what the lawmakers are intending. Is you cannot say today, for example, you went and you distributed blankets, right? You have distributed blankets, you have distributed food packets. Can you say it's a case of CSR? Do you think it's a case of CSR if you have distributed, blankets or food packets? I'm sure most of you will say yes. Or I'm not sure if you want to say no to that. But we need to understand that, for example, Schedule 7, what does it say? It states, so let me take you to that slide so that you'll understand. Schedule 7 has to be interpreted very liberally. That's for sure. But that doesn't mean that we start engaging ourselves in philanthropic and charitable activities. That's not the intent of law, right? Because what is intended is that you need to make a change in the society. You have to uplift the society. Not that you keep, contributing blankets and food packets, and by doing that, you are making a change in the society. What change will that have? Let's say if your company is distributing food packets or blankets, and by that you're saying that you are eradicating poverty, you are eradicating hunger. Can you say that? While one can be inclined to say that it's eradicating poverty or hunger, but please understand that you are not eradicating poverty or eradicating hunger. You're actually supporting that. Why? Because you are not giving them something which they will be using as a part of earning their livelihoods. They'll become dependent on you. That today you have distributed food packets, tomorrow again you'll be distributing food packets, so they need not do anything. Right? So one needs to understand that CSR is not like doing one-time activity. There has to be a proper blueprint, there has to be a proper plan in place as to which areas in the society the company wants to make a change, and company should be engrossed and engaged in those activities specifically. Of course, I'm not saying that if health and sanitation is one of the priority projects, it cannot contribute for any other project under Schedule 7. The answer is not that you cannot. You can. Of course, you can. But as a part of a long-term strategic vision, which companies should have, putting money for one-time activities should not be advocated for as a CSR activity. There's a question from Mr. Prakash Patel. It is, if company has transferred amount to IA, but IA has not spent, is the company eligible? So I think I dealt with that question, Mr. Patel, that if you have parked the money with the IA, but the IA has not spent, right? You cannot say that the money has been spent. In your books, in your reporting, it's still an unspent CSR amount. And here also, I would like to make a point that CSR, doing it by way of an implementing agency and doing it for the beneficiaries directly, there is a very thin borderline which we all need to understand. So, for example, I took an example of A Limited, I took an example of XYZ Foundation, and of course, there were the end use beneficiaries. So, in the case of XYZ Foundation, if this foundation itself runs schools, right? It runs small education houses, and I am giving this money to XYZ Foundation. Can I say that money has been gone to an implementing agency? The answer is no. In this case, where the money has gone to to an entity which is itself carrying out the activity, that means the money has gone to the beneficiary. So in that case, taking care of unspent account, or asking for the CSR prerequisites of an IA like registration, etc., is not mandatory. There's a question from Ms. Sneha Bhavnani. It is, if a company has set up a Section 8 company, which is an IA, and this Section 8 company further collaborates with different NGOs and NPOs for execution, then will such NGOs also be considered as IA for the company? Okay, so Sneha, we will try to understand this question in this fashion, that let's say A Limited was the company. It has set up B Limited, which is a Section 8 company. Now, B Limited has collaborated with several NGOs for a CSR project. I have to see to whom A Limited is giving the money. If A Limited is giving the money to B Limited, which is a registered implementing agency, so I will be reporting B Limited as my implementing agency. Now, B Limited in turn involves or engages any third party for its implementation, identification, that the implementing agency will see from its end. From my end, or for my reporting purposes, I will hold B Limited responsible for whatever happens. There's another question from Mr. Patel. Can IA have relative of a company as trustee? So here then we are talking about a situation where we have, this is very common, in fact, that we have these captive trust or group company trust. So there are several big companies in India which we know, and they all have their own trust. And in those trust which they have set up, most of the times the promoters of the company are only trustees. So there is no specific restriction, and of course there is no problem at all. The only thing that you need to keep in mind here is that when you're making a contribution to such an entity, where your promoters, your directors, they have some kind of a linkage, you have to also examine the contribution being made to a related party angle. So that angle needs to be evaluated, and sure enough, I think audit committee approval should be taken for such contribution. There is another question from Mr. Ajay. What is meant by spending? What if the fund has been paid to IA? I think this we have already dealt, Mr. Ajay, that it will not be taken as spent. There's a question from Mr. Mane, which is, how can we measure CSR activities in non-profit company? So if this question can be explained, I think I'm not very sure on the question. If Mr. Indra Sen is there, he can be unmuted and he can say what exactly he wants to ask. Rachit, you are there?
Yes, ma'am.
Is there a possibility that we can unmute Mr. Indra Sen so that he can explain what he wants to ask in case he's there in the room?
I can check with the technical support for
that. Okay,
yeah,
so that,
hello, Richard.
that,
we have an opportunity for this. So I'm making an option there where the participants can, raise their hands to speak, and we can accept that.
Right. So
the option enable now.
What we'll do is we can I can take up other questions in the meantime, and once we get to see the hands raised, Rachit can let me know, and we can then pause till they can ask the questions.
Sure.
Okay, there's another question from Mr. Lakshmi Narayan Acharya. What are the documents to be obtained for CSR spending when the company is directly spending on CSR? For example, if company wants to give computer to a school or some medical instruments to hospital. Actually, yeah. So, sir, as you rightly asked, there is this confusion that if I am contributing directly, what should I take as a part of my reporting or a monitoring exercise? So, ideally, what should be the procedure here is that I should receive a requisition first from any entity who is wanting that, that support or the funding support. The company should, let's say if the company is doing it directly, the company should be examining the authenticity and how bona fide the request is. Based on its examination, it should, of course, disburse the funds as per its, limitations, or as its allocated amounts are. And once the amount has gone, of course, it will receive a receipt from that particular entity that we have received so much amount for so and so. And at the most, what you can do is that once the hospital or the school has spent that money, that means they have actually spent the money to buy that equipment or that particular product, they can share that receipt with you. But it's not that till the time they don't share that receipt, you will take your money to be unspent. No. If it's a case of a direct CSR, there is no question of unspent amount. Once you've given the money, it's spent. When the beneficiary actually spends is immaterial. They will spend it as per their requirements. The next question is from Mr. Divakaran. Section 135/5 prescribes mandatory spending. Can a company spend voluntarily even though the company does not satisfy? Answer is yes. If you want to voluntarily spend under Section 135, you can. And there is no issue in that. You will have to simply, if you want to spend, or a company which is not required to spend, if they spend, what they can do is they can take credit of the spending that they've done for the subsequent years when they actually get covered. So till such time, whatever money they are spending in is a excess CSR spending, which they are not supposed, which they are not required to spend. But if you're following all the protocols, you are, setting up a committee, framing a policy, putting in the money, that is, you're completely in sync with the requirements. So the time or the year where the CSR provisions actually become applicable on you, you can take benefit of the excess CSR spending in case you want. How likely is it for penalty to be attracted if a company transfers unspent amount to a fund after September? So this question is from Ms. Payal Jain, and so Ms. Jain, how likely it is, I will not be able to say how likely it is, but yes, considering the manner in which ROC and the regulatory authorities are nowadays monitoring the activities, we should not be reluctant to comply, because here I would like to mention one more thing, that this penalty amount, if you are unable, if you're not spending and you have not transferred the amount, so this penalty is of course it needs to be paid once imposed. If you are not complying with any other provision of the CSR, this thing, like for example, constitution of a committee, framing of a policy, then this penalty is not attracted. But this, Section 450 comes into play, which is a general penalty section, but not specifically this. But yes, if you ask me what is the likelihood of your company being asked for a penalty, I will say yes, there is much likelihood, because you can receive notice from the ROC anytime. Another question from Sneha. It's as per the latest MCFAQ's, admin amount spent by IA cannot be claimed as a part of admin overhead. However, if a company is not spending any such admin expense, then should the amount incurred by the IA not be considered as admin overhead? So, Sneha, while there is this view given by the MCA, but we respectfully differ from this view because uh, the administrative overhead has to be seen from the contributors' angle. So, let's say if I am the contributor and I have given the money to the IA is making the expenditure, and so because IA is not the beneficiary, so whatever admin overheads or administrative overhead it has incurred, it's actually as good as incurring by the contributors part. So me as a company incurring that admin overhead or my IA incurring that administrative overhead is the same, and that has to be within 5% limit. But yes, whatever administrative expenses the beneficiaries incur, that need not be taken into account. There is this question again. Section 135 by 6 says CSR amount to be transferred. Is there any violation if I spend it directly from my running business account? No. See, this requirement is very, very clear that we need to have a separate account where I'm putting in this or parking this funds so that it is not mingled with my business funds. So it cannot be given from my running business account. I think that's it from the questions that we have. If there are any other questions, Rachit, you can help me with those.
Yeah, ma'am, one of the participant has raised his hand. Can I accept the request?
Yes, please.
Okay. I have accepted the request from Indrasan, Mr. Indrasan. Let's see if he's available now.
Okay, till the time the participant who has raised his hand is speaking, I will take the question of Mr. Ajay Pusarkar. Can you please explain admin expense incurred by an IAS? So, as I mentioned
Jay
during the
has also, yeah, he has also raised his hand. I'm
right,
accepting his
so I'm just
request.
right. So, will they be able to speak up, or they can
Yeah,
only post the
they will
questions?
be. Yeah, they will
Okay.
become the presenter there, and they will be able to speak.
Okay. So I think I've understood Mr. Ajay's question. So I want to take that question. So what is an administrative overhead? I have discussed during the deliberation because administrative overheads, it has, if you look at the definition, it has actually excluded a lot of things. It has excluded the cost of implementation, cost of identification, cost of monitoring, cost of evaluation, right? So these four things are already excluded from administrative overheads. So what is there? So for example, if a company is carrying out the CSR expenditure through an IA, and the IA has is let's say incurring cost to train up its employees for CSR work, that expenditure can be taken as an administrative overhead by the company, because administrative overheads will have to be seen from the contributors angle. So here when I'm saying I'm the contributor, I'm A limited, so I have this 5% limit or for the admin overheads. That 5% limit also travels to my IA and not to the beneficiary. So, for example, in one example, I said that XYZ Foundation is running a school and I am contributing to that XYZ Foundation. So, it's not a case of me giving money to an IA. It's a case of me, the company, giving funds to the beneficiary altogether. So, there is no question of, admin overhead.
Mr. Ajay and Mr. Anderson has joined us.
Yes, so I think I have answered Mr. Ajay's question. In case any further clarification is required, you may let me know, Mr. Ajay.
Yes, first of all, thank you for organizing this webinar, and this is very helpful. The question is still regarding this 5% admin expenses, uh, which flows on to this implementing agencies. Uh, as per the income tax rules, also, income tax allows 15% of the retention out of the donation received for that year to incur against the admin expenses. When we say admin expenses, it covers all your non-field staff expenses or the other fixed overheads that you incurred, like setup of your office, your HR and admin, then business development team. That is the cost it covers under. So I believe this 5%, the limitation or the C's that we have is on the company side who actually pays off for the CSR and not on the implementing agencies. So
Yeah, so while you are correct on that fact that we have to see this 5% limit from the company's angle, right? But when this amount is being given to an IA, the IA is not a beneficiary. It's not receiving the donation for its own use, right? It's actually receiving the money for actually routing it to the beneficiaries. So if I am taking the help of the implementing agency for my CSR activities, the view that we hold is that 5% admin overheads has to be seen from the company's angle. And if the company has engaged in implementing agency, which is not the beneficiary, please keep that in mind. We are not talking about the one who's receiving the donation. When we are giving money to the IA, it's not donating to the IA. It's actually parking funds with the IA for being actually spent on the CSR activities. So that admin overhead 5% limit should also be applicable on an IA.
fair enough. Yeah. Thank you. Thank you so much.
Yes, ma'am. Now we have Mr. Anderson as well.
Yes, ma'am. Hello.
Yes,
Yes,
sir.
ma'am.
Hi.
Can you hear me, ma'am?
Yes, I can hear you, sir.
Ma'am, my question is this: if our organization is a new organization, okay, there is a no any profit, no any loss, okay, new organization. So that time, how can we run CSR activities and CSR related things in our company? It was any startup, matlab ki it was any starting point of the that CSR.
So first of all, if your company is a new company, right, and
Yes.
it is not meeting any of the thresholds,
Yeah.
that is the threshold of turnover, net worth, or profit.
Hmm. Hmm.
So it is not covered under Section 135. If it is not covered, there is no question of any expenditure.
Okay.
I can see one question from Ms. Hina Shah. Allocated CSR funds are to be parked in separate account and from their expenses are to be made. Yes, Ms. Shah, that's the correct answer. Yes. The answer is yes. It has to be done from that account. There is another question from Mr. Jain. Earlier, company was covered in CSR threshold, but since last 3 years, it does not meet the criteria. Okay. Hence, whether CSR compliance, etc., needs to be done. If yes, then till what time? So, if your company is not meeting the thresholds from the past 3 years, so there is no question for you to either. I mean, of course, even if you see the rules, if for 3 consecutive years you fail to meet the CSR thresholds for applicability, in that case you will not be required to even have the committee. You can dissolve the committee in that case, right? So no committee, there is no need to have a policy, but you may already have a policy in place, so that can policy be there in the dormant stage. No spending requirements and no reporting. You can simply have a disclosure to this effect in your annual report or board's report, that because this year the company is not the applicable provisions of 135 is not applicable, hence there's no reporting separately being done. Any time limit for parking funds. So there are two time limits, Ms. Shah. In case the unspent amount is related to an ongoing project, in that case, the funds are to be parked in the unspent CSR account within 30 days from the end of the financial year. And if the unspent account relates to a not ongoing project, in that case, the amount The unspent amount has to be transferred to any fund under Schedule 7 within 6 months from the end of the financial year. I think we are done with the questions. Yeah,
Ma'am, there is one more request. If you allow, I can accept
please,
that.
please. Yeah, sure, sure, sure. No problem.
Yeah, I have accepted a request from Mr. Fried too. I think he will become the presenter now.
So, can we have the question?
He is not available, ma'am, so we can wind up.
Okay, no
Ranjit,
problem.
over to you.
Thank you so much, ma'am, for clearing our concepts on CSR provisions. The presentation was excellent, and the way you use the illustrations and examples in the presentation has really helped us in understanding the practical aspect of the provisions. I, on behalf of Taxmann, thank you for taking out time and being here today. Thanks for sharing your profound knowledge and practical experience with us. Thank you all participants for joining us in making this webinar interactive and successful. The link for PPT and recorded version of the webinar will be made